First of all, let me thank Joan for this very nice introduction, and also for the organizers for having me here today. The topic of our panel has been more than explained. My personal presentation will be divided. Let me just confirm which is the one. This one. Okay, so this is how I'm going to organize my presentation. It will have essentially three parts. And firstly, I shall provide my personal opinion on if such organizations, professional arbitral organizations, should or not have any role. Secondly, I will address the IBA. As Jean mentioned, I am currently an officer of the IBA, and so I will address the IBA's achievements or major achievements, in my opinion, in this area, focusing especially on the IBA guidelines on conflicts of interest. And finally, I will briefly analyze a specific case of Portugal, making reference to the Portuguese Arbitration Association Code of Ethics and how Portuguese courts have interpreted and applied both the IBA guidelines and the Code of Ethics in recent cases. And I would begin the first part of my presentation with this tentatively amusing slide, I hope. Well, basically, as you all know, most arbitration laws or institutional rules resort to vague concepts when referring to arbitrators' duties, such as the concepts of independence and impartiality. But who controls this? Well, we have four layers. Firstly, we have the arbitrator who's invited to act as such in a given case, who obviously must assess if he or she is independent vis-à-vis the parties that or their counsel. This opinion may, however, be challenged by the parties, normally before the tribunal itself or before the institution that is administering the case. And so a second level of control arises before that's exercised by the parties themselves when analyzing if they agree with the arbitrator's analysis. If a party does not agree with that analysis and then decides to challenge the arbitrator, a third level of control will be exercised either by the tribunal or the institution, as the case may be. And finally, in many situations, ultimately, the decision will fall upon state courts who, of the seat of the arbitration, who may be asked to review the decision made either by the tribunal or by the institution in some cases. The profession of arbitrators is not, as opposed to that of counsel, regulated by professional organizations such as national bar associations or law societies. Actually, as Charles just mentioned, we only belong to these organizations if we want to. It's voluntary. So there is no professional body to which parties, arbitrators or state courts may resort when they are faced with a situation in which a doubt arises as to the eventual non-fulfillment of the duties of independence and impartiality. The fact remains that arbitrators, when deciding to accept an appointment, tribunals and institutions, when having to decide challenges, and ultimately state courts, when they're called upon to decide on the accuracy of the findings of the tribunals or the institutions, will need to apply these concepts of independence and impartiality to a concrete situation. The question then is it useful to have guidelines, codes, practical guides that may provide guidance to all these players? I believe it is useful indeed, for a number of reasons. Well, first of all, arbitration, notably international arbitration, has become the most resorted to mechanism for resolving disputes in international commerce. And arbitral awards, even in domestic cases, may have to be enforced in a number of jurisdictions. Let's imagine, for instance, that in a domestic dispute, it is impossible, upon a positive award, to seize assets because there are none available. However, there are assets in another jurisdiction. So even in a domestic award, you may have to seek recognition and enforcement elsewhere. So basically, both when deciding eventual setting aside proceedings or recognition proceedings, state courts may be called upon to assess grounds of public policy, notably in respect of the alleged lack of independence or impartiality of a given arbitrator or member of a tribunal. For these reasons, it's useful, in my personal opinion, that these notions of independence and impartiality carry some sort of uniformity throughout the world. But then a second question arises, which is who is supposed to define these concepts and how they are to be interpreted? So, as I said, there's no universal body to decide this. I don't think it will be possible, at least in the very near future, to have any such body that would regulate the profession as a whole. And so market best practices play an extremely important role. But these market practices are not necessarily accessible to those who don't usually work within the market. State courts, although extremely important as gatekeepers of the arbitral process, are not de facto part of the arbitration market. New players arrive on the so-called arbitration market every day, counsel that's not used to working in arbitration, arbitrators who are appointed for the first time. And as such, it's useful to have these standard market best practices in writing and thus available to all those who may need to resort to them, from prospective arbitrators to counsel, institutions, state courts. And then a third question arises: who is supposed to put these best market practices in writing? Well, given that there's no universal body, the answer appears to be that arbitral professional organizations will necessarily play an important role. And the more universal the reach of those organizations, the more important their role will be, even more so because they may eventually influence local or regional professional organizations and thus contribute to spreading best market practices throughout the world. Which brings me to the IBA. So the IBA, established in 1947, is essentially the world's leading international organization of legal practitioners, bar associations, and law societies. As you may see on the slide, it has over 80,000 individual members, over 190 member bar associations and law societies that span, by the way, over 170 countries. And one of its main goals is precisely to promote an exchange of information between legal associations worldwide. And it does so through its divisions, its committees, and constituents. On the next slide, I know it's not very readable, but basically you can see the organization of the IBA. It has two committees. One is the legal divisions. One is the legal practice division, which is basically organized, and one of its goals is to promote the interchange of information and views among its members as to laws, practices and professional responsibilities relating to the practice of law throughout the world. Within the legal practice division, you will find the dispute resolution section, one of the 19, which in turn comprises 5 committees. One of those is the arbitration committee, of which I'm honored to be an officer. The work of this arbitration committee focuses on the laws, practices and procedures relating to arbitration of transnational disputes. And through conferences, publications, projects, it seeks to share information about international arbitration, promote its use, and obviously improve its effectiveness. Now, the first document that was prepared by the IBA in respect of arbitrator ethics, with the rules of ethics for international arbitrators, in 1987. However, they weren't as successful as expected. And so in 2002, the IBA organized a working group that was aimed at addressing the problems of conflicts of interest. The main goals of this working group were to consider how useful the existing standards by which impartiality and independence of arbitrators were assessed, to formulate new standards for situations that had not previously been addressed, and also to try to set forth standards that could be accepted by different legal cultures. To this effect, this working group analyzed 13 country reports ranging from countries such as Australia, Belgium, Canada, France, Germany, so on and so forth. And in these reports, the members of the working group were basically asked to compare the existing IBA rules of ethics from 1987 with the standards and practices in their own jurisdictions. The working group concluded that it appeared that the IBA rules of ethics were generally more stringent than the standard practice in most jurisdictions, and that as such they should not be treated as a minimum standard. After 2 years of work, this ultimately led to the approval in 2004 of the IBA guidelines on conflicts of interest in international arbitration, which was since revised in 2014. And this leads me also to a very important document, which I will skim through. But basically, there's a subcommittee of the Arbitration Committee which is devoted to monitoring the guidelines and rules of the IBA, which was organized in 2015. And basically, this subcommittee was set up to to conduct a worldwide survey on the use of these instruments. And to inform its work, it developed and distributed a questionnaire, having received 845 meaningful responses. And on the chart, you may see the breakdown of responses that was received by region. They also requested and assessed a total of 55 country reports from a variety of countries, analyzed the responses collected, and came to a number of conclusions that are set out in a quite extensive report, which you may find on the IBA website. And basically, the next few slides, you'll see some information about the key conclusions that were reached. I will try to go through them very fast. As I said, you can find more information on the IBA website. But basically, the guidelines have gained broad acceptance, very often used in international arbitration community, and of the three instruments that were surveyed, they were definitely the one that was most used. 57% out of 3,201 arbitrations known to all respondents in the 5 years preceding the study. Also, when acting as counsel, practitioners consulted or relied on the guidelines in the selection of arbitrators even more than the guidelines were generally referenced in arbitrations. On the next slide, you will see that also the arbitrators appeared to make frequent use of the guidelines across all regions. There are two slides. One respects to the cases of arbitrators when deciding an appointment, and the other when making decisions as to whether facts should or not be disclosed. Another slide will show you that the guidelines were often referenced by the relevant decision makers, arbitral tribunals, institutions, or even courts when reaching a pronouncement on the existence of conflicts of interest. But perhaps more importantly, the next slide reflects that 69% of those decisions that reference the guidelines, actually the decision maker chose to follow them. I will skip through the next slide. As I said, you can look it up on the IBA website. But basically, the last one of the questions posed, and this slide is interesting, should they be changed or not? Should they be amended? And the results are those that you may see on the slide. Regardless of personal opinions that one may have on the IBA and on the guidelines, I know, Carmona, that you're itching to slash out at me, but or in any particular aspects thereof, the results of the study do clearly show the reach that the IBA has throughout the world and how important the guidelines have become on a worldwide basis. Very quickly, just to go through the last part of my presentation, basically, development of modern arbitration in Portugal is quite recent. We had a dictatorship until 1974, which wasn't very nice. And so we didn't have a lot of arbitration. The first act dates back to 1986, but it didn't make any reference to requirements such as independence and impartiality. It was only in 2012 that this actually was expressly set out into the law after an enactment of a new law that was prepared by the Portuguese Arbitration Association, also a non-profit organization that aims to foster knowledge and use of arbitration. But even before that, the Portuguese 2012, the Portuguese Arbitration Association had in fact elected as one of its goals and succeeded in approving a code of ethics that was very influential in the community and led to some institutions also following suit and enacting similar codes of ethics. So even before the 2012 Act, this topic of ethics, notably independence and partiality, was very much in the highlight. In the following slides, I will very quickly go through a couple of decisions that illustrate how Portuguese courts have resorted to both national and international soft law instruments when assessing matters of independence and impartiality. So I won't bother you with reading what's on the slides, but as you see, these two cases are cases that actually applied the 1986 Act, which didn't have a reference to independence and impartiality, and show how important resorting to international soft law instruments was considered both by the Supreme Court in 2011 and later on by the Court of Appeals of Porto in a decision rendered in 2014, but applying the previous law. In the next slide, you will see 3 decisions that relate already to the 2012 Act, but that once again, in all 3 of these decisions, and there are others, I just tried to select the ones that I thought had the most attractive expressions. But basically, all these decisions refer to the IBA guidelines, to the Code of Ethics of the Portuguese Arbitration Association, to the recommendations of the Spanish Arbitration Club on independence and impartiality, as well as other instruments. And so we do have had 1 or 2 decisions recently from administrative courts which are not so positive, but regardless of the decisions which have to be viewed in a very specific national context, the conclusion remains that Portuguese courts frequently resort to international soft law instruments when assessing matters related to independence and partiality of arbitrators, which in my view confirms the importance of the role that such type of instruments have in setting the standards for arbitrator conduct throughout the world. Thank you very much for your time.